This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to thank each of you for agreeing to participate in this oral argument via Zoom. We believe it's the best way for us to continue to do the business of the judiciary and yet keep everyone safe. So we agree to you. We appreciate you agreeing to participate with us like this. Having said that, all the same rules, procedures, and protocol that would be in effect as if we were standing in the courtroom are in effect for today's argument as well. Essentially, that means that each of you will get 15 minutes to make your oral argument. If you are the appellant and you've reserved rebuttal time with Mr. Hibner previously, then you will also receive that rebuttal time. I want to remind you that we are live streaming this argument, so it is being broadcast. Also want to remind you that in the event that we have any kind of technological glitches, everybody just remain calm. We will make sure to get those resolved, and we'll also make sure that nobody's prejudiced as a result of that. Before we get started, I want to introduce today's panel for you, or this afternoon's panel. We have Judge Skip Frierson from Morristown, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
You may call the case.
Vantisha Evans-Barken versus Madison County, Tennessee.
And we will hear from the appellant.
Yes, Your Honor. May it please the court, my name is Nathan Tilley. I represent the appellant, Madison County, Tennessee, in this matter. Your Honor, this case arises from an appeal of the Madison County Chancery Court's review of the Madison County Civil Service Board's decision to uphold the appellee Vantisha Evans-Barken's termination from the Madison County Sheriff's Department. That termination occurred in April of 2016. The issue in this case is whether Sheriff John Mayer, the Madison County Sheriff, possessed just cause to terminate Ms. Barken from her position from the Madison County Sheriff's Department, and concurrently whether the Chancery Court erred in remanding the case back to the Civil Service Board and directing it to consider further evidence based on its review. You know, Your Honors, we think the answer to this case is pretty simple. It's pretty straightforward. At the time that Sheriff Mayer terminated Ms. Barken, she had lost her Peace Officer Standards Training Commission certification, otherwise known as post certification. And because she had lost her post certification, Tennessee law mandated that Sheriff Mayer could no longer employ her as a deputy with the Sheriff's Department. Specifically, Ms. Barken failed a mandatory psychological examination, and that failure led to losing her post certification. Not only did Tennessee law mandate that she no longer serve as a deputy, had Sheriff Mayer continued to employ her as a deputy, he would have committed a crime under Tennessee law. So we think the answer, as I will further explain, is pretty simple here. And the Civil Service Board, when it heard the proof in this case, recognized that Sheriff Mayer had no choice but to terminate Ms. Barken, and found that he indeed possessed just cause to do so, and therefore upheld her termination. Now, nonetheless, the Chancery Court, we believe erroneously, after its review, concluded that the Civil Service Board should have considered appellee's evidence more thoroughly in making its determination. And because it did not do so, it violated appellee's due process rights. It had a finding that was arbitrary and capricious, and it used an improper procedure in coming to its conclusion. We think that's wrong, and that's what I'm going to explain to you today. And basically, we think it's wrong because the proof appellee offered, that she was given the opportunity to offer, just simply did not matter to the question of whether Sheriff Mayer possessed just cause to terminate her. And so we're here today to ask this court to overturn the Chancery Court's ruling and to uphold the Civil Service Board's decision approving Ms. Barken's termination. Now, Your Honors.
Let me ask you, Mr. Tilley.
Yes, Your Honor.
Civil Service Board, when it's conducting its review, is that a de novo review?
It is a de novo review, but it is a review under the Madison County Civil Service Act. It is a review to determine whether the sheriff possessed just cause to terminate. And if the proof shows that he did possess just cause to terminate, then the Civil Service Board is directed to approve that termination.
Well,
and
I think, Mr. Tilley, if you're conducting a de novo review, you really don't give deference to the previous decision that's been made. You consider all of the evidence that's produced at that de novo hearing, is the way I understand that. Is that not true?
But they did consider all the proof. They did consider all the proof that was presented at the hearing. I think that the point, though, is that Ms. Barken's proof at the hearing was an attempt to attack the psychological evaluation that was performed by Dr. Emily Davis. But the plaintiff and Ms. Barken presented two expert witnesses who basically attacked Dr. Davis's qualifications. They attacked the methods that she used. They attacked the tests that she utilized. But at the end of the day, Dr. Davis was qualified by Post to make the certification decision, whether it's qualified or not qualified. And the second she says she's not qualified to serve as an officer, she fills out a form. It's an exhibit in this case. She signs it and she marks not qualified. When she does that form is given to the Post Commission. And when the Post Commission receives that, Ms. Barken is no longer certified as an officer. And so that's when I come back to what I just said previously. It doesn't matter how strenuously Ms. Barken argues that the psychological evaluation wasn't done correctly or appropriately, because the fact remains Dr. Emily Davis had the authority to do it. She did it. She made the determination. It was reported to Post. And because it was reported to Post decertified Ms. Barken. Sheriff Mayer didn't have a choice. He could not continue to hire Ms. Barken as a deputy because Tennessee law required her to pass that psychological evaluation.
Let me ask you, does it matter here that Dr. Davis conceded that she didn't have the qualifications to make a psychological diagnosis? And as I understand post-certification, you have to have a disqualifying psychological condition. And if Dr. Davis was not qualified to make that diagnosis, that Ms. Barken's had a disqualifying condition, what would give that decision just cause?
Well, Your Honor, it matters. This is what matters. What matters is that Dr. Davis, she has been doing this for years. She's been doing it for 7 different counties across Tennessee. I think in 2015, she did 150 of these evaluations. In 2016, she did 175 of these evaluations. Post has never said she doesn't have the authority to do it. Post has always relied on her opinions. And in her testimony, she testified that based upon what she saw from Ms. Barken, that Ms. Barken did have a disqualifier because she had reportedly had PTSD. That is also in the proof that there is a doctor's note in this case that shows that she had PTSD. And the fact that she was qualified or not qualified to make that diagnosis, that's not the test. Under the statute, she was qualified to perform these evaluations, and Post has always recognized that she's qualified to perform these evaluations. But I think
let me ask you, where do we find in the record this doctor's note that she was diagnosed with having PTSD? We're going to be found in the record.
Your Honor, I believe that was Exhibit 6 to the Civil Service Board hearing. And And here's just a point that I think is very important for the court to recognize. And that is, if Dr. Davis was not qualified to make this determination, if she was out of bounds in what she did, Ms. Barken had the opportunity to challenge her findings via post regulations, because post regulations provide that if you lose your certification, there is an appeal process that can be undertaken via post. And when you exhaust that process, you can file a writ of cert in Chancery Court for it to review it. She didn't do that. She never did that. So right now, today, as we sit here, and as at the time of the Civil Service Board hearing, Dr. Davis's conclusion that she was not qualified on April 1st, 2016, it has never been overturned. It has never been invalidated. It remains valid. And because of that finding, she was decertified. Ms. Barken was decertified. The Civil Service Board does not have the authority to post-certify somebody. It doesn't have, no matter what proof Ms. Barken put up, she could have put up that Dr. Davis had absolutely no basis to make the findings she did. It would not matter, because pursuant to post, she's still decertified. If Ms. Barken wished to challenge Dr. Davis's authority, she could have challenged it via the post appeal process that I just referenced, but she didn't do that. Now, Your Honors, I think it's Ms. Barken has heavily relied upon, I'm sure you've seen it in the briefs, the case Smith v. White. And I think I would be amiss not to talk about that case just a little bit. That case is very different than this case. In that case, the officer had been designated a perpetrator of child abuse by DCS. And because of that designation, the Sheriff's Department terminated. But what did the officer in Smith v. White do? He did what Ms. Barken did not do. What he did, he challenged the DCS findings by appealing through DCS and then filing a case in Chancery Court. And the Chancery Court found that that designation was not supported. And therefore, the Chancery Court overturned the decision that designated him a perpetrator of child abuse. Well, the Court of Appeals, on appeal from the Civil Service Board, said because the underlying issue that caused your termination was invalidated by the Chancery Court, the Civil Service Board should have reinstated you. That's not what Ms. Barken did here. She never undertook the proper due process procedure that's provided for under Tennessee law to challenge her decertification via post procedures. She never did that. Instead, she came to the Civil Service Board and tried to attack Dr. Emily Davis's qualifications. It doesn't matter. That's not how you would go about obtaining post certification. And I certainly don't believe that this court would entertain granting Civil Service Boards the authority to determine post certification, when the Tennessee legislature has clearly laid out that authority lies with post and only with post, and for good reason. Your Honors, I believe I'm out of time. I'm happy to answer any questions, or I'll save for rebuttal.
Hear from the appellate.
Thank you, sir. Brad Hornsby of the Rutherford County Bar, and I'm here representing Vantisha Evans. What the appellant has failed to tell you is that Dr. Lewis is not a doctor of psychiatry or a doctor of psychology. She has an educational doctorate. Not to say there's anything wrong with that. She's legitimately a doctor, and I use the term, but she does not have the qualifications to make such a diagnosis. Now, she gave one test, the MMPI-2 test. It's an outdated one, but it's still valid. It showed no mental diagnosis that prevents her from doing the job. She did a second test, the MCMI-3 test. She didn't attach it to the report, but it also showed my client has no mental defect or diagnosis whatsoever, much less it prevents her from doing her job. She did an evaluation of 10 to 15 minutes, which isn't sufficient. And that what was mostly interesting is she said that she turned my client down solely based upon her sworn testimony of PTSD at a hearing, which was a nurse practitioner who wrote something in documents. She has never been diagnosed as having PTSD. Luckily, she probably never used the term, I was depressed, because Dr. Lewis would have diagnosed her with severe depression. But she doesn't have the qualifications to make that diagnosis. Matter of fact, not only did she do that, she said she never even discussed it with my client. She had a duty to ask her, do you have PTSD? Why do you think that? And then the second question is, does it prevent you from doing your job? Because you can have a mental defect or disease and still do your job. As an example, if you're an investigator and you're OCD, that may be a very good trait to have. Someone who's a little on the anal side, gathering facts. But we have Dr. Ronoff that comes in and says this impulse test she did has nothing to do with mental defect or disease. This is an employment test, which is irrelevant because she's already been employed. If you want to rate different prospective employees, that may be a fine test, but it has nothing to do with post-certification, has nothing to do with mental disease or defect. All the tests that were given to her by Dr. Lewis showed my client was within the range of what's normal. I don't know if anybody's really normal, but she's within the range of what's normal. There is no mental disease or defect listed. If she had gone and said, here, I reviewed the reports from Dr. Smith, a psychologist out of Tennessee, and his diagnosis is she has this, she still had the second step in saying, does it prevent her from doing her job? Because many police officers arguably could be involved in a shooting and have PTSD, but they could still be an officer, because the question is not do they have PTSD, but do they have it, and does it prevent them from doing their job? Dr. Avery gave her the full spectrum of tests. She specialized in research PTSD. Both Dr. Ronoff and Dr. Avery have PhDs, and they gave her the full independent fitness for duty evaluation. And both of the, she came to the conclusion my client does not have any diagnosable impairment. What the county wants you to do is review only what Sheriff Meyer knew. That's not a de novo hearing. De novo hearing is what are the facts as they exist at the time. When we showed up,
let me ask you.
Yes, sir.
Without an approved post-certification, could the sheriff return your client to work?
At that time, arguably not. However, when we showed up at the de novo hearing, she was post-certified. That was also not in dispute. She had been diagnosed and evaluated by Bonnie Bearcott Smith and was working at the Mason City Police Department.
No, but at the time that the sheriff made his decision, she had not been post-certification certified. Is that right?
That is correct. But here's the question is the sheriff allowed to rely solely on a faulty evaluation? If so, then I guess arguably we lose this case. But I don't think that's the law in the state of Tennessee. When you have a de novo hearing, you look at the facts as they exist at the date of the hearing. The chancellor did not substitute his judgment. He basically told the board, you made findings that the evaluation was inadequate. She did not do a good evaluation. You did not look at any of the other facts, and that's what he sent it back. The Smith v. White case, we would respectfully submit, is on point, because Smith v. White says, let's look at the facts as they exist at the time of the de novo hearing. Now, in that particular case, a deputy was accused of child abuse. He was indeed, quote, it was put down as a, quote, founded allegation. It went to DCS. They also made a finding that it was founded. On appeal, the sheriff then terminated him. So then we go back to the time of the de novo hearing. The sheriff arguably did the right thing in Roane County at that time by making the firing, because at the time there was a finding that he had been indeed founded of child abuse. But as we get there to the time of the hearing, the board in that particular case said, let's look solely at what the sheriff knew at that time. And this court, and I say this court, it's actually the Knoxville court. The Knoxville Court of Appeals said, no, a de novo hearing says you look at the facts at that time. So as the deputy showed up showing that it was unfounded. My client showed up with post-certification, where the deputy basically says there was a bad investigation done. That's exactly what we did. We showed up at that time saying the evaluation done by Dr. Lewis was inadequate. The board, said Dr. Davis was, quote, underqualified. She improperly conducted an evaluation. We like the board findings. We agree with them. But by doing that, the board said we still stuck with that. So in essence, if you look at this, the sheriff has the right to basically make a bad decision based on bad facts. And when the facts truly come out that indeed my client is post-certified, and she was post-certified at the time of the hearing, that she should be indeed getting her job back.
Let me ask you,
yeah.
that post-certification by another law enforcement agency, could the sheriff here rely on that post-certification to
Yes,
make
sir.
his decision?
Yeah, I don't think it's in dispute. Sheriff Meyer does not want my client to work there. He fired her the first day he got on job. He's been trying to terminate her every time since then. Because I even asked him at the hearing, you now know she's post-certified. You know the evaluation was inadequate. Will you take her back? His answer was no. And I'm sorry, Judge, if I interrupted. I didn't intend to. I thought.
No, you answered my question.
Yes, sir. But I think in this particular case, the board in Smith v. White case upheld the termination saying, what did the sheriff know? And the Court of Appeal said, it's not important what the sheriff know. Let's have a de novo hearing, because a de novo hearing says whatever the sheriff knew or should have known is somewhat not irrelevant. We're going to have a brand new hearing. And when the evidence comes out, I think Ms. Barken could sit there and say, I meet all the qualifications, return to duty. The county wants you to be like Paul Harvey and not hear the rest of the story. They get the first part of it, but as the rest of the story goes, the rest of the story was the investigation by Dr. Lewis was pretty poor. She gave 2 tests, both of which said she has no mental disease or defect that prevents her from doing her job. She relied on a statement of a nurse practitioner who did not make an official diagnosis and didn't even have the opportunity, would not even talk to my client about, do you have PTSD? At the hearing, it was uncontroverted. My client had never been diagnosed with PTSD. And all the Dr. Lewis would have to do was ask her, have you ever been diagnosed? That answer would have been no. So it's our position that in this particular case, you have to have your de novo hearing, because if we solely look at what the sheriff knew, then Smith v. White is now bad law, because Smith v. White says when you have your de novo hearing, you look at the facts as they exist at the time of the hearing. And we think that is what should be done. Dr. Lewis did not do a good examination. Dr. Aronoff verified that. She gave a test that has no scientific validity. She hid one, didn't even attach it. The MCMI3 test was not included in her evaluation. We have an expert, Dr. Avery, who specializes in PTSD and post-certifications, did the entire evaluation, says she meets the qualifications for post-certification. My client went and got post-certified. So at the time of the hearing, she was post-certified. So the question is, knowing what the sheriff knew at the time is somewhat, I'm not saying he made a bad decision, but in essence, you're taking any review away if you prevent us from putting on any proof of what the facts really are. And the facts, as they completely come out, is Dr. Lewis did not do really a good job like she's supposed to, like the board found, and he relied on it. And as a result, we had no opportunity, according to Madison County, to even challenge it. We should be able to sit there and say, if we wanted a de novo review, we should be able to say that evaluation was improper, and the facts as they exist at that time are that she indeed meets all the qualifications for the job. We would respectfully submit, you basically have a couple options. One is here, you could order the chancellor to overturn the board. I think the facts are sufficient that out there based on their findings, that based on the facts, she should indeed, the board's decision should be overturned and she should be reinstated. Or you honestly, we respectfully request you can actually have her ordered reinstatement based on the facts. The facts are uncontroverted in this case. Dr. Lewis did not do a good job. My experts did a good job. They questioned it.
Arguing, you mean Dr. Davis, don't you?
Dr. Davis, yes, Dr. Davis. Sorry, sir. Thank you, sir.
Let
But when you look,
let me ask you, Mr. Hornsby.
yes, sir.
We really don't have a decision by the trial court about whether to overturn the termination or approve the termination. So do we have a decision on the merits in this case?
I would respectfully submit that you could indeed, because when it was appealed to the chancellor had the option, looking at the record, which was all submitted to him, to say, based on the record, the board's decision should either be affirmed or disproved or not affirmed. And we'd respectfully say, you can sit there just like the chancellor did. The chancellor sent it back to the board to basically say, do your job. Look at all the evidence. We would respectfully submit that the chancellor could have, by looking at the same evidence, could have actually either affirmed or disproved their ruling. And we would respectfully submit that you can indeed look at the facts and say the board was in error and the chancellor should have set aside the firing and there was no just cause.
Then you're asking us to make the initial decision that the chancellor didn't make about whether to approve or overturn the termination, aren't you?
Yes, in the alternative, yes, sir. I do think you do have the option of affirming the chancellor and going back to the board, but honestly, I'd respectfully, so we may be right back to the chancellor shortly thereafter. I think you have either option. I'm not going to tell you all how to do your job, sir.
Let me ask you,
I'd respectfully say that we
do
would
you
like
handle a number of these kinds of cases? Have you handled a number of these kind of cases in the past?
I've handled in 40 something years, I've handled everything from MSPB to employment cases. I've had to handle some. Yes, sir.
All right. In connection with these cases where there's a judicial review and the trial court decides that the case should be remanded, have you ever handled an appeal simply because the trial court ordered the case to be remanded? Because I can't find a case where that's ever occurred.
I'd respectfully agree with you. I was in a situation where there's a serious question whether or not the chancellor's order is even a final order, because he basically has said, I don't think I have enough. We want the board to do their job, So if you affirm the decision, in essence, we're going to go back to the board to evaluate the exact same facts that you have properly before you today.
Okay.
And I hate to say that, but I have a minute left over, and I guess I can reserve that for the next time I have an argument, sir.
Okay.
Thank you.
Thank you, sir.
We'll hear a rebuttal from the appellant.
Yes, Your Honor. Your Honors, the Smith v. White case is very different than this case. In this case, Ms. Barken never undertook the procedure that is available to her under Tennessee law to overturn Dr. Davis's decision not to qualify her for post-certification. She never did that. What she did is she waited 6 months later. She went to another law enforcement agency and she took the test again. And this time, 6 months later, she passed. I don't know. Maybe her mental ability had improved. I'm not sure why she passed 6 months later, but it was a different test. I'm reminded of the bar exam, Your Honors. Many people fail the bar exam, and when they fail it, they can't practice law. They can take it again, and maybe they'll pass it. And at that point, they can practice law. But the underlying first test that they failed is still a failure. And when Sheriff Mayer terminated her, she had failed the test. In Smith, what we found is...
Let me ask you a question, Mr. Tilley.
Yes, Your Honor.
Are you saying, I'm having difficulty following your argument. Are you saying that the appellee here didn't have the right to challenge the examination before the board?
I am saying that, Your Honor. Exactly.
How
Because-
can that be due process?
Because she has due process under post regulations to do that. What if she had come to the board and said, look, post overturned her decision. If she had put that proof up, then she would have an argument that Sheriff Mayer should do something different and she can be reinstated. But she didn't.
Okay, but what you're saying is rather than the board having the decision-making authority, it's the examiner who has the decision-making authority, because no matter what the board does, if the examiner says, I think you failed, that's the end of the discussion, isn't it?
It's the
Under your theory.
No, it's not, because she can appeal to post. She can go to post and say, I disagree with the examiner's decision, and she can bring expert testimony in a hearing before post. But the Tennessee legislature has given post the authority to make post certification. And appellee is asking this court to allow civil service boards the ability to review post certification decisions. That's not in the purview of the civil service board. That's in the purview of post. If she had come to the civil
You've
service
used your time, Mr. Tilley.
Yes, Your Honor.
All right. We appreciate your argument. We will take this matter under advisement and will render an opinion at the earliest time possible. Again, appreciate your participating via Zoom. Mr. Hibbert, anything we need to take up before we recess?
No, Your Honor.
All right, you may recess court to the call of the next case. Thank
This
you.
court is now in recess until 2 p.m. Council, you may leave.